Okay, everybody. Josh Denbo, New Jersey consumer attorney, and I want to do a series of answering common questions that I receive in my practice. So one of the most common I receive is, what happened to my modification? I signed, I did what I was supposed to do, I submitted the application, they came back with a trial payment plan. If it was required of me, I signed it and sent it back, and I made the payments, and then everything just kind of stopped, and I don't know what happened. So there are two problems that come up after that, two fact patterns. One, the bank comes back and says, you never returned the final modification application signed, so we declared that you rejected it and we're going to go forward with the foreclosure. And that's a bad thing. It's also very, very bad when the modification was reached right before sale. My clients often tell me they never sent me the application. I paid for 6 months. It was a 3-month trial. I signed a 3-month trial. I did everything I was supposed to do. I would immediately have signed the final modification offer if it had come to me, but it didn't come to me, so I didn't sign it. Now they're telling me I'm in default because I didn't sign something that I didn't receive. That's one fact pattern. Another fact pattern is I did everything I was supposed to do, then the servicing changed, and the new servicer either said to me, we don't care what the old servicer did, it doesn't count, or we don't have any record of it, so we need you to reapply. Both of those things are nonsense. The first is the new servicer that comes in, they stand in the shoes of the old servicer. They're entering into the contract representing the owner of the loan for everything that the owner of the loan is obliged or has a right to. And the owner of the loan is entitled to collect the payments that it's entitled to collect, but it's also obliged to abide by the contracts reached on its behalf by its prior servicer. So the new servicer argument has nothing to do with us. That's a lie. It's common. People believe it. And the suggested resolution that you simply go reapply is a very common tactic. And it works when people are working with out-of-state modification companies who are not New Jersey attorneys and sometimes not attorneys, because they don't know what to do. They're like, oh, all right, that makes sense. Do another application, and sometimes it works out, but a lot of times it doesn't. More importantly, every single time that statement is made, we don't have any records of it, you have to reapply, the servicer and the owner of the loan has violated federal law and you have a right to sue them. So let's get back to the bigger question. What do you do when a mortgage servicer says something along the lines of, we're not going to abide by the modification agreement you signed? You pick up the phone, or you more likely get on your computer and you start searching for people who can help you. And to be completely candid and truthful and honest, there are not many lawyers who can help you with this. This is not normal standard contract law. This is not normal standard mortgage law. This is not normal standard Consumer Fraud Act law. This is the Real Estate Settlement Procedures Act statute, which is a federal statute, and there are only a handful of lawyers in New Jersey who handle this work. There's me, there's Javier Marino, there's Ira Metric, there's John Fazio. Maybe another two, one or two, I don't know. That's it. So be very careful when you reach this fact pattern if you're working with somebody who tells you anything other than you have a right to sue, to force the bank to give you what you're entitled to make them pay your lawyer's fees and your damages, and to avoid the problem of following the instructions, submitting a new loss mitigation application, and then when that comes back as either denied or worse than the first one, ending up in a situation in which the bank says, well, you reapplied, so even if we're wrong and didn't send you the final judgment, the final modification application, or whatever reason, because you applied for a new one, it means you don't want the old one, so judge, don't give them the old one even though it's a lot better. That's a problem that I really don't want to have to deal with again, but I deal with it all the time because people deal with the wrong lawyers and the wrong out-of-state modification companies. And by the way, the wrong out-of-state modification company is every out-of-state modification company. Okay, be strong, be well, be smart. Talk to you soon.